The first shot cracked across the lake at 6:11 in the morning. My horses heard it before I did. 3 geldings near the south pasture jerked their heads up at once, then bolted away from the shoreline fence, while a flock of ducks exploded off the water and disappeared into the gray dawn mist. I set down the feed bucket and looked toward the opposite bank, where 2 private security guards in matching uniforms stood near a temporary survey marker, their truck parked beside the access road that led toward the future Bluewater Ridge Resort site. Then a second warning shot echoed across the water. That got my attention. A woman stood beside a dark SUV about 50 yards away, arms folded, watching the entire thing unfold like she was inspecting a construction project. Evelyn Mercer Hargrove, president of the Bluewater Ridge Community Association. The same woman who had spent the last 6 months telling anyone who would listen that her $24 million resort was the future of our county. The same woman who kept insisting my ranch was standing in the way of progress. One of the guards pointed toward my shoreline. Evelyn never looked away from me. Message received. I walked back toward the house instead of toward them. That surprised them. Most people expect anger. Most people expect shouting. I had something better. By 6:32 a.m., I was on the phone with the sheriff's office requesting an incident report. By 6:47, every security camera file from the shoreline was copied onto 2 separate hard drives. By 7:15, I had emailed my attorney and attached time-stamped video clips showing exactly where those guards were standing when the shots were fired. Paperwork first. Always. See, Ravenwater Ranch isn't some abandoned piece of land people forgot about. My family has owned it for generations, and every fence line, shoreline marker, and water allocation record is documented down to the inch. Evelyn knew that. What she believed was something different. She believed pressure worked faster than law. She believed if she made enough noise, delayed enough meetings, and created enough headaches, eventually I'd get tired and sign whatever agreement her developers pushed. Across the table. She was wrong. Before lunch that same day, I drove to the county records office and requested certified copies of the latest permit filings connected to Bluewater Ridge Resort. After that, I photographed every new survey stake that had appeared near my property boundary during the previous week and logged each location. Then I sent a preservation notice to the HOA, the security contractor, and the development company instructing them not to destroy any communications, emails, reports, or footage related to the incident. That matters more than people realize. A lot more. Here's something most folks never learn until they're already in a dispute. Arguing on the roadside creates memories, but certified notices create evidence. One disappears. The other survives in court. By sunset, I already had a growing file. Incident report, video footage, survey photos, email records, contractor names, license plate numbers. Not bad for a single day. Still, the problem wasn't going away overnight. The sheriff's deputy who reviewed the footage explained exactly why. The shots appeared to be fired away from people and structures, which meant the situation wasn't automatically becoming a criminal case. The county couldn't halt construction activity based only on a dispute over property rights. They needed documentation, surveys, records, legal review. It was frustrating, but it was real. That's how these things work in the real world. So while Evelyn celebrated another day of construction activity, I sat at my kitchen table with a yellow legal pad, a stack of county records requests, and a growing suspicion that something about her project didn't add up. Not the financing, not the permits, the water. Something about the water kept bothering me. Before I went to bed that night, I replayed the security footage one more time. There was Evelyn standing beside that SUV, watching those warning shots echo across my family's lake. Calm. Confident, certain she was winning. I remember looking at the screen and saying one sentence out loud, even though nobody else was there to hear it. You might want to tell your investors to stop spending money until somebody checks the water file. At the time, I didn't yet know how important that file would become, but I was about to find out. And if you're watching from a ranch town, a farming community, or anywhere people still believe property lines mean something, pull up a chair and stay a while. Stories like this have a funny way of teaching what paperwork is really worth. The next morning, I spread 3 generations of paperwork across my kitchen table and finally started tracing the trail that led to everything sitting in front of me. The old documents smelled faintly like dust, leather, and the kind of storage boxes families keep for decades because nobody wants to throw away a piece of their history. Outside the window, the lake was calm again, and if you did not know better, you would think nothing unusual had happened. That was the illusion. My grandfather, Walter Callahan, bought the original Ravenwater parcel in 1948. Back then it was just over 600 acres of grazing land, timber, and shoreline wrapped around a spring-fed lake that most people in the county barely noticed. When he passed away, the property transferred to my father through a recorded deed filed at the county courthouse, and when my father died, the ranch transferred to me through a family trust that had already been reviewed and recorded years earlier. Simple, clean, documented. Nobody had to guess who owned the land because the answer was sitting in black ink inside county records anyone could request. I pulled out the most recent deed and read the legal description again, slowly, line by line. The deed identified the parcel boundaries, the acreage, the shoreline, and every recorded transfer going back decades. Then I unfolded the parcel map. That map mattered. The parcel map showed exactly where Ravenwater Ranch ended, where neighboring properties began, and where a narrow access easement crossed a small section of the northern edge of my land. That easement would become important later. Very important. A lot of people hear the word easement and assume it means ownership. It does not. An easement is permission for a specific use. Nothing more. The one crossing my property allowed utility crews and maintenance vehicles to pass through a designated corridor when necessary. That was it. It did not allow anyone to build structures. It did not allow anyone to charge fees. It did not allow anyone to lease the land. It did not allow anyone to claim control over the property. It certainly did not allow anyone to build a resort. Different things entirely. Around noon, my attorney, Rachel Bennett, called after reviewing the files I had emailed her the previous evening. "Everett, I checked the recorded documents this morning," she said. "Ownership is exactly what you thought it was. Any surprises?" I asked. "Only one," she replied. "Somebody seems to be acting like that easement gives them authority it does not actually provide." That got my attention. Rachel explained that several recent planning documents referenced access rights in a way that could confuse people unfamiliar with property law. A person reading them quickly might assume the resort development had broader rights than it actually did. The wording was careful, not exactly false, but definitely misleading. That bothered me. Later that afternoon, I drove along the north boundary and stopped near a cluster of fresh survey flags planted beside the easement corridor. Some were legitimate. Others seemed oddly placed. I photographed every one of them. Then I compared their locations to the parcel map sitting on the passenger seat of my truck. The positions did not match. Not even close. By the time I returned home, another piece of the puzzle had fallen into place. Evelyn was not telling people she owned my land because she knew she could never prove that. Instead, she was letting people assume her project had rights it did not actually have. There is a difference. A huge difference. That evening, as the sun settled behind the hills and turned the lake orange, I opened another storage box from my father's office and found something I had not looked at in years. Inside was a thick folder labeled Water Allocation Records. I almost set it aside for later. Almost. Then I noticed a handwritten note clipped to the front in my father's handwriting. The note contained only 7 words. "Protect these. Someday, somebody will need them." The following week, I started seeing something that bothered me more than the survey flags. People were repeating the same talking points almost word for word. At the feed store, at the gas station, even outside church on Sunday morning, neighbors who had never shown much interest in the resort suddenly started talking about safety upgrades, emergency access improvements, and economic growth. The phrases were nearly identical. That was not an accident. A few days later, one of my neighbors, a retired school bus driver named Hank, stopped by the ranch carrying a printed packet he had received from the HOA. He handed it to me and said, "Everett, I figured you should see this because your name is all over it." I sat down on the porch and started reading. The first page described the resort project as a community asset that would improve property values and create jobs. The second page discussed road access and emergency response times. The third page was where things became interesting. Very interesting. The packet included a summary of a newly approved HOA resolution claiming that future infrastructure improvements would require coordinated access agreements across neighboring properties. The wording sounded official. It sounded reasonable. It also left out some important facts. The resolution never claimed ownership of my ranch because nobody could support that claim. Instead, it created the impression that certain development activities already had broad authorization simply because the HOA board had voted in favor of them. That is not how property law works. Not even close. A recorded deed controls ownership. A board vote does not replace a deed. A resolution can tell HOA members what rules apply inside their community. It cannot magically expand property rights onto somebody else's land. That afternoon, I drove to one of the contractor staging areas and introduced myself to a project supervisor named Kyle. He looked exhausted, sunburned, and more interested in finishing his paperwork than arguing with anybody. When I asked whether his company had received owner authorization documents for certain planned utility routes, he immediately pulled out a binder. That caught my attention. Inside were copies of project summaries, access diagrams, and emails referencing coordination with surrounding landowners. One email specifically mentioned expected cooperation from neighboring properties. I pointed at the line and asked, "Did anybody ever show you a signed agreement from me?" Kyle looked down at the page and paused. Then he flipped through several sections. Then another. Then another. Nothing. His expression changed. Fast. "No," he admitted. "We were told the access issues had already been resolved." There it was. Somebody had convinced contractors that permissions existed when no actual agreement had been executed. Not fraud. Not yet. But definitely a problem. Meanwhile, Evelyn continued holding community meetings every week. Attendance kept growing because she knew exactly which buttons to push. She talked about future tourism revenue. She talked about protecting property values. She talked about preventing traffic congestion through coordinated planning. Most importantly, she warned residents that delays could jeopardize infrastructure improvements and future investments. Fear works, especially when people think something valuable might be taken away. By the end of the month, several residents were openly blaming me for slowing progress. Some believed I was trying to force developers into paying me unreasonable amounts of money. Others thought I simply disliked change. Neither was true. I never opposed legal development. I opposed pretending permissions existed when they did not. One evening, I attended a public information session and sat quietly near the back. Evelyn stood at the front beside a large map showing roads, utilities, walking trails, and future resort facilities. Then she pointed toward a section near the lake and said, "All necessary access coordination is moving forward as planned." I did not interrupt her. I did not argue. I simply took a photograph of the slide. Then another. Then another. Because while everyone else was listening to promises, I was collecting evidence. And by then, a pattern was starting to emerge that was much bigger than a misunderstanding over a ranch. Boundary. Most people think legal disputes are won by one dramatic piece of evidence that suddenly changes everything. Real life is usually much less exciting. Real life is stacks of paperwork, long drives to county offices, phone calls that go nowhere, and dozens of small facts that slowly lock together like pieces of a puzzle. That was the stage I had entered. I was not waiting anymore. I was building a file. The first thing Rachel and I secured was a certified copy of the ownership chain for Ravenwater Ranch. Not a photocopy. Not an old family record. A certified county copy carrying official seals and recording information. That document served one purpose. It established beyond argument who owned the land. If anybody later claimed confusion about ownership, that excuse would disappear immediately. One piece secured. Then we ordered a title report from a regional title company. The report traced recorded interests attached to the property and confirmed what we already suspected. The utility easement crossing the northern edge of the ranch was narrow, limited, and specific. It allowed passage under certain circumstances. It did not authorize development. It did not authorize construction staging. It did not authorize commercial operations. It did not authorize control. That distinction mattered. A lot. A week later, a licensed surveyor named Nathan spent 2 full days reviewing markers, monuments, boundary descriptions, and historical maps. He carried equipment that looked like something from a science fiction movie, but the result was surprisingly simple. His certified survey showed several recently placed project flags sitting outside areas where they should have been. Not by miles. Not by huge distances. Just enough to matter. Sometimes 6 feet. Sometimes 12. Sometimes 20. Small mistakes become expensive mistakes. Nathan handed me the final survey package and said, "If this reaches a hearing, Nobody is going to like these measurements. I took that as good news. Next came permit files. That process took longer because county departments do not move quickly. We requested development permits, utility reviews, environmental submissions, engineering summaries, and infrastructure planning records connected to the project. Several weeks later, boxes of documents began arriving. Most were boring. Hundreds of pages of boring. But hidden inside those pages were details worth their weight in gold. One engineering report estimated future water demand during peak tourist season. Another projected irrigation requirements for landscaping and common areas. Another discussed long-term sustainability planning. Every report seemed to assume the same thing without directly proving it. Reliable water access would exist. Assumptions are dangerous, especially expensive ones. While reviewing the permit files, Rachel highlighted a paragraph and slid it across the conference table. "Read this line," she said. I did. Then I read it again. The report referenced expected regional water availability, but did not identify a finalized source agreement. That was unusual. Not illegal, just unusual. Another piece clicked into place. Meanwhile, I continued documenting activity around the ranch. Every survey marker received photographs. Every contractor vehicle entering adjacent staging areas was logged with dates and times. Every public presentation slide was saved. Every community email I received was archived. Some evenings felt more like accounting than ranching. But records do not forget. One afternoon, I filed a formal request for body camera footage connected to the deputy response from the incident near the shoreline. The footage itself was not dramatic. That was exactly why I wanted it. The deputy documented the location, the participants, and the circumstances in a neutral manner. Independent records carry weight. More weight than personal opinions ever will. Around the same time, contractor invoices surfaced through public filings related to utility planning. Those invoices showed engineering consultations focused on future water distribution infrastructure. Again, nothing illegal. But each document confirmed the same pattern. Money was being spent. Designs were being finalized. Expectations were being sold. Yet nobody seemed eager to explain where the long-term water supply was actually coming from. Then came the witness statements. Hank agreed to provide a written account regarding the HOA packet he had received. Another resident provided copies of community emails describing access coordination as though major property issues had already been resolved. A local contractor confirmed he had been told neighboring landowner cooperation was expected. Not guaranteed. Expected. Words matter. By the end of that month, my evidence file contained certified deeds, title reports, surveys, permit records, engineering studies, photographs, emails, body camera documentation requests, contractor records, and witness statements. Each item served a different purpose. Ownership, boundaries, access limits, project assumptions, public representations, future obligations. Standing alone, none of them ended the dispute. Together, they were becoming something much more dangerous for anyone relying on half-truths. And buried deep inside those engineering records was a phrase that kept appearing over and over again in different forms. Water allocation dependency. The more I saw it, the less I liked it. The phrase kept showing up everywhere I looked. Water allocation dependency. It appeared in engineering summaries. It appeared in planning notes. It appeared in technical reviews written years apart by completely different consultants. The wording changed slightly from document to document, but the meaning stayed the same. Somebody, somewhere, expected access to water that had never actually been secured. That was when I stopped asking what the project needed and started asking a different question. Who benefits? One rainy Tuesday morning, Rachel called me before sunrise. Her voice carried the tone she used whenever she found something important. "I think you need to come into town," she said. "Bring the water records." 30 minutes later, I was sitting across from her conference table while she spread several financial documents across the surface. Most people would have fallen asleep looking at them. I almost did. Then she pointed to a series of projected revenue estimates connected to the resort development. The numbers were enormous. Future lodging revenue, event revenue, marina revenue, membership revenue, vacation package revenue. Everything depended on the resort opening on schedule. Everything. Then Rachel pointed at another section. "Look at this." I leaned closer. Several investor updates described project milestones that would trigger additional funding releases. If the project stayed on schedule, more money arrived. If construction slowed, money could be delayed. If critical infrastructure became uncertain, investors gained the right to reevaluate participation. Suddenly, the pressure campaign made a lot more sense. Delays were expensive, very expensive. The deeper we dug, the more connections appeared. Evelyn was not officially listed as a project owner. She was smarter than that. Her position sat in a gray area where influence often matters more than ownership. Through HOA leadership, she had become the public face of growth in the region. Local business groups invited her to speak. Community newsletters quoted her regularly. Real estate marketing materials referenced her development vision. Her reputation was becoming tied directly to the success of the project. Success had value, real value. Then we found another layer. One consulting company advising the resort had previously completed work for the HOA. Nothing illegal about that. Companies work with multiple clients all the time. But the relationship explained why certain assumptions kept moving smoothly between HOA communications and development planning documents. The same people were often involved in both conversations. The circle was smaller than it appeared. A few days later, another document surfaced through a public records request. This one caught my attention immediately. It outlined long-term HOA financial projections after the resort opened. According to the estimates, future assessments collected from commercial activity would significantly improve the association's financial position. That mattered because the HOA was not nearly as healthy as residents believed. Maintenance costs had increased. Several infrastructure projects were running over budget. Reserve funding was thinner than public presentations suggested. The resort was not just a luxury project anymore. It was becoming part of the solution to a growing financial problem. There it was. Money. During the following week, Hank stopped by the ranch again carrying another community newsletter. We sat on the porch while he shook his head. Every issue says the same thing, he said. Future growth. Future opportunities. Future value. I flipped through the pages. He was right. The messaging never changed. Progress. Growth. Opportunity. None of those words are bad by themselves, but they become dangerous when people stop asking questions. Later that evening, I reviewed another batch of emails obtained through lawful requests and disclosures. Most were routine scheduling messages. A few discussed construction timelines. Then I found a thread that made me sit up straight. One consultant had raised concerns years earlier regarding long-term water sourcing assumptions. The response did not deny the concern. Instead, the reply suggested the issue could be resolved through future cooperation with surrounding landowners. Future cooperation, not signed agreements, not recorded rights. Cooperation. That distinction mattered more than anyone realized. Somebody had built a $24 million plan around an expectation rather than a guarantee. The more I studied the records, the more one fact became impossible to ignore. The project did not appear to be moving forward because all major questions had been answered. It appeared to be moving forward because people hoped the unanswered questions would eventually solve themselves. Hope is not a legal strategy. And then Rachel found the document that changed how we viewed everything. It was an investor presentation prepared years before the public ever heard about the project. Buried deep inside the appendix was a risk assessment section discussing future water sourcing. Most of the page was routine. Then one sentence jumped out at both of us. Access to regional historical water allocations remains a key operational consideration. I read it 3 times. Then a fourth. They knew. Maybe not everyone involved. Maybe not every investor. But somebody had understood the dependency years before the first survey flag ever appeared near my ranch. Somebody knew the project's future rested on water rights they did not control. And instead of solving that problem first, they chose to build momentum, attract investment, create public expectations, and hope nobody looked too closely at the foundation underneath it all. The hardest part was not proving what I knew. The hardest part was making sure I did not hurt people who had nothing to do with the problem. By that point, I could see frustration spreading through the community. Construction schedules were slipping. Rumors were growing. Residents were hearing different versions of the same story depending on who they talked to. Some believed I was preparing to shut down access roads. Others thought I planned to block contractors from entering the area. A few even claimed I was going to cut off utilities to force negotiations. None of that was true. Not even close. One morning, I found a handwritten note tucked into my mailbox from a resident I had never met. It was short. Very short. Please do not punish the rest of us for what the HOA is doing. I sat there holding that piece of paper longer than I probably should have. Because the truth was simple. The families living there were not my enemy. The school bus driver traveling those roads every morning was not my enemy. The delivery drivers bringing groceries and medication were not my enemy. The nurse commuting to the county clinic was not my enemy. My dispute was with decisions, not people. So I made a deliberate choice. I would challenge documents, permits, and representations. I would not create problems for ordinary residents. That decision shaped everything that followed. Rachel agreed completely. During one meeting, she looked across her desk and said, "The moment you interfere with lawful access, you become part of the story instead of the person exposing the story." She was right. So instead of closing gates, I documented traffic. Instead of confronting contractors, I communicated through formal notices. Instead of escalating tensions, I expanded the record. Paper beats anger. Every time. Over the next several weeks, we sent certified notices to every party directly involved. The HOA received one. The development company received one. The engineering consultants received one. The environmental review team received one. Even the project's lenders received notice that ownership disputes and unresolved water allocation questions existed. None of those letters accused anyone of crimes. That was intentional. Each notice simply documented facts, attached supporting records, and requested preservation of evidence. Simple, professional, difficult to ignore. Around the same time, I submitted information packages to the County Water Board and the State Environmental Office. Those packages included certified ownership records, title documents, surveys, engineering references, and correspondence already gathered through lawful channels. The goal was not to stop development immediately. The goal was to ensure regulators had accurate information before making future decisions. That distinction mattered a lot. One afternoon, while reviewing records at home, I noticed a county maintenance truck parked near the northern access corridor. A few months earlier, I might have assumed they were connected to the project. Now I knew better than to jump to conclusions. So I walked over and introduced myself. The crew leader explained they were inspecting drainage structures unrelated to the resort. We chatted for 10 minutes. Then I thanked them and left. No drama. No accusations. Facts first. Assumptions last. Meanwhile, pressure inside the HOA appeared to be increasing. Community newsletters became more aggressive. Public statements focused heavily on delays and uncertainty. The language was carefully crafted. Nobody directly blamed me by name. They did not need to. The implication was clear enough. Yet something interesting started happening. Residents began asking questions. Real questions. Questions that had not appeared during earlier meetings. Questions about permits. Questions about infrastructure. Questions about long-term water sources. Questions about financial exposure if project assumptions proved inaccurate. Once people start asking questions, controlling the narrative becomes much harder. During another public meeting, a resident stood up and asked whether all required water rights had been secured. The room became noticeably quieter. Evelyn answered smoothly. She always did. She spoke about planning processes, regional cooperation, and ongoing evaluations. What she did not provide was a direct answer. I noticed several people exchange looks. They noticed too. After the meeting ended, a contractor I recognized from earlier site visits approached me in the parking lot. "You are not trying to shut everything down, are you?" he asked. "No," I replied. "I am trying to make sure everybody is working with accurate information." He nodded slowly. Then he said something that stayed with me. "That is different." Yes, it was different. Because if I had wanted revenge, I could have spent my energy creating disruption. Instead, I spent it creating documentation. If I had wanted headlines, I could have picked public fights. Instead, I built files. And while the community argued over rumors, I continued assembling a record that was becoming impossible to dismiss. The regulators now had copies. The lenders had copies. The consultants had copies. The attorneys had copies. The evidence was no longer sitting in a box on my kitchen table. It was moving through the system, exactly where it needed to be. And somewhere inside that growing stack of documents was a problem large enough that nobody wanted to discuss it openly yet. Not because it was complicated, because it was expensive. About 3 weeks after the regulators received the latest document packages, notices began circulating for a public county hearing. The official purpose sounded harmless enough. County staff would review infrastructure readiness, environmental compliance updates, utility planning, and long-term operational requirements connected to the development. On paper, it looked like another routine administrative meeting. In reality, everybody knew it was much bigger than that. By then, rumors had spread far beyond the neighborhood. Local reporters planned to attend. Investors planned to attend. Business owners planned to attend. Even people who had never cared about zoning meetings suddenly wanted a seat in the room. The stakes were becoming impossible to ignore. The hearing was scheduled for a Thursday afternoon inside a county conference center overlooking the river. When I arrived, the parking lot was already crowded. Pickup trucks sat beside luxury sport utility vehicles. Contractors stood near county engineers. Residents gathered in small groups comparing notes. Everyone seemed to sense that something important was about to happen. Nobody knew exactly what. That uncertainty filled the air. Inside the building, long rows of chairs faced a raised hearing table where county officials would conduct the proceedings. Large display screens had been installed for exhibits and presentations. Stacks of documents sat on nearly every surface. The room looked less like a public meeting and more like a courtroom without the judge. That was fitting. Evelyn entered about 20 minutes before the hearing began. She moved through the room confidently, greeting investors, shaking hands with local business leaders, and speaking with reporters. Several people approached her with questions. She answered each one smoothly. She looked exactly like someone expecting a victory lap. Confidence was not her problem. Overconfidence might be. I took a seat near the back beside Rachel. Between us sat several binders filled with documents gathered over months of investigation. Certified deeds, title reports, survey certifications, engineering studies, regulatory correspondence, financial records, email chains. None of it was dramatic by itself. Together, it told a story. A very expensive story. Rachel noticed me looking around the room and quietly asked, "Nervous?" I thought about it for a second. "Not really," I replied. Prepared. That was the truth. The waiting was over. The evidence had already done most of the work. Once the hearing started, county officials walked through standard agenda items first. Road improvements, environmental mitigation measures, utility corridor updates, construction timelines. The audience listened politely. Then the discussion moved toward water infrastructure planning. The room changed immediately. People sat straighter. Pens started moving. Reporters leaned forward. Everyone knew this was the section that mattered. An engineering consultant representing the project delivered a polished presentation using maps, charts, and projections. The visuals looked impressive. Future demand forecasts appeared on giant screens. Operational models appeared next. Long-term growth estimates followed. The presentation was professional. Very professional. Yet one thing still bothered me. Every chart showed expected water availability. None showed guaranteed water rights. There is a difference. During a question period, one county official asked a simple question. Can you identify the finalized source supporting projected long-term demand? The consultant paused. Not long, just long enough. Then he began discussing regional availability studies, ongoing evaluations, and future coordination efforts. It sounded technical. It also sounded familiar. I had seen the same language inside those documents months earlier. The same careful wording. The same missing answer. Around me, several audience members exchanged glances. They noticed it too. Then Evelyn requested an opportunity to address the room. She stepped forward with complete confidence and spoke about community benefits, economic growth, tourism opportunities, and future prosperity. Her presentation was polished because she had probably given versions of it dozens of times. The audience listened. Some nodded. Some applauded. Everything appeared to be moving in her direction, exactly as she expected. Meanwhile, Rachel quietly slid a folder toward me beneath the table. Inside were the final hearing exhibits approved for submission earlier that morning. Every certification had been completed. Every supporting document had been authenticated. Every reference had been organized and indexed. Months of preparation sat inside a single binder. I opened it and reviewed the tabs one final time. Ownership records, water allocation certificates, survey findings, permit references, internal communications, investor materials, technical reports. The foundation was ready. Across the room, Evelyn continued answering questions from officials and reporters. She looked relaxed, comfortable. certain the discussion would end the way every previous public meeting had ended, with more support, more momentum, more confidence. What she did not realize was that the hearing was no longer about promises. It was about proof. And for the first time since this entire fight began, every person who mattered was sitting in the same room at the same time, looking at the same documents, listening to the same answers, and waiting for the same question that nobody had been willing to confront directly. Where exactly was the water supposed to come from? The question hung over the room for several seconds after the county official asked it. Nobody interrupted. Nobody shuffled papers. Even the reporters stopped typing. The answer should have been simple. If a project expected to use a long-term water source, there should be documentation identifying that source. There should be agreements. There should be recorded rights. There should be something. Instead, the room sat in silence. Then the consultant returned to the microphone and started talking about future planning discussions, regional opportunities, and cooperative solutions. It sounded polished. It also sounded like someone carefully walking around a hole in the ground without admitting the hole existed. The county official thanked him and turned toward the audience sign-up list. My name was called a few moments later. I stood, carried one binder to the presentation table, and plugged a laptop into the display system. The large screens behind me lit up. Every eye in the room followed. This was it. I started with the simplest document in the entire case. Ownership records. No dramatic speeches. No emotional appeals. Just certified county documents showing the chain of ownership for Ravenwater Ranch. The first screen displayed the recorded deed. The second displayed the parcel map. The third displayed the easement corridor. I want to begin with something simple, I said. This easement allows limited passage through a specific area. It does not transfer ownership. It does not authorize construction rights. It does not authorize commercial control. Then I highlighted the recorded language itself. Words matter, especially recorded words. Several county officials leaned closer to read the screen. A few audience members began taking photographs. Then I moved to the survey evidence. Certified survey maps appeared next. Boundary markers, property lines, easement limits, distances, measurements. Everything verified by licensed professionals. The survey established where rights existed and where they did not. Again, nothing emotional, just facts. Then I displayed the engineering reports. The atmosphere changed immediately. Charts filled the screens showing projected water consumption during peak operating periods, irrigation requirements, hospitality demand, recreational demand, long-term usage estimates. One county engineer quietly adjusted his glasses and studied the numbers. Another started making notes. They were paying attention now. These projections are not my calculations, I explained. They come directly from project documents. Then I showed the next exhibit. Water allocation dependency references highlighted across multiple reports spanning several years. Different consultants. Different dates. Same concern. Same dependency. The room grew noticeably quieter. Next came the water rights records from my family's files. Certified historical allocations. Recorded references. State-recognized rights associated with the property. Maps identifying source locations. Supporting documentation. The screens displayed page after page. Nobody interrupted. Then I reached the document Rachel and I had spent weeks verifying. The investor presentation. The one buried deep inside archived records. I displayed the relevant page and enlarged a single section. Access to regional historical water allocations remains a key operational consideration. The sentence appeared on the giant screen behind me. Nobody needed help reading it. Then I displayed the date. Years before public construction planning accelerated. Years before community meetings. Years before most residents even knew the project existed. Several heads turned toward Evelyn. For the first time all afternoon, she stopped smiling. I was not finished. The next exhibits consisted of internal communications. Carefully authenticated. Properly submitted. Reviewed by counsel before. Presentation. One email referenced concerns about future sourcing assumptions. Another acknowledged unresolved dependency questions. Another discussed expected cooperation from neighboring landowners. Not secured agreements. Expected cooperation. The distinction was impossible to miss now. A county official interrupted. To clarify, are you saying these documents indicate awareness of unresolved sourcing issues? Yes, I replied. That is exactly what I am saying. Then an environmental consultant invited by the county requested permission to review several exhibits directly. He spent nearly 10 minutes examining maps, certificates, and engineering references. The room waited. Finally, he returned to the microphone. His statement was short, very short. Based on the documents presented today, I do not see evidence of an alternative finalized water source capable of supporting projected operational demand. The room froze. Reporters immediately started typing again. Investors looked at one another. County staff exchanged documents across the table. Even people who did not fully understand property law understood that sentence. Water is not optional. Then another official asked a question that hit even harder. If these historical allocations are unavailable, can the project currently operate as represented? The consultant hesitated, this time longer than before, much longer. Then he answered, additional review would be necessary. That was not a yes. Everyone knew it. The balance of power shifted right there in front of everyone. Not because I had shouted louder. Not because I had embarrassed anyone. Because the documents spoke for themselves. The assumptions that had carried the project forward for years were suddenly visible. Publicly visible. Officially visible. The hearing had started with questions about whether I was slowing progress. It ended with a much larger question facing the entire room. What happens when a project worth millions depends on rights it never actually secured? The fallout did not happen in a single afternoon. Real consequences almost never do. The hearing ended with more questions than answers, but now those questions belong to county officials, lenders, regulators, investors, and attorneys instead of one ranch owner sitting alone at a kitchen table. That changed the direction of everything. Within 2 weeks, the County Water Board issued a temporary suspension on approvals connected to long-term water sourcing until additional verification could be completed. State environmental reviewers opened a formal review of the supporting documentation submitted during the project approval process. The lenders financing portions of the development requested independent assessments before releasing additional funds. Suddenly, everyone wanted paperwork. Lots of paperwork. The first major result involved the investors. Several investment groups argued they had relied on representations suggesting critical infrastructure questions had already been substantially resolved. Negotiations followed. Auditors became involved. Financial disclosures were reviewed. Eventually, a settlement process required portions of certain investment deposits and participation funds to be returned under revised agreements. The exact numbers varied from investor to investor, but money moved back out instead of continuing to flow in. That got people's attention. Then came the legal fees. Because the dispute centered on documented property rights, access representations, and regulatory submissions, portions of the final settlement framework required the development entity and its insurance coverage providers to absorb substantial legal expenses connected to the dispute. Rachel smiled the day she told me. For once, she said, the paperwork is paying its own bills. That felt appropriate. Meanwhile, independent auditors began reviewing several HOA communications, financial assumptions, and board actions tied to the project. The audit was not about whether people liked development. It was about whether members had received accurate information while major financial decisions were being promoted. Records were examined. Communications were reviewed. Timelines were compared. Facts matter, especially recorded facts. As pressure mounted, leadership changes followed. Evelyn eventually stepped down from her position. Additional governance reforms were adopted, including restrictions preventing certain board members involved in the controversy from immediately returning to leadership roles while reviews remained ongoing. No dramatic speeches. No public shouting. Just consequences arriving one document at a time. The development itself did not disappear overnight. That would not have been realistic. Instead, the project was forced back into the planning stage regarding long-term water sourcing. Portions of the infrastructure plan had to be revised. Permit applications required updates. Several proposed elements dependent upon unsupported assumptions were removed or redesigned. Expensive changes. Very expensive changes. Back at the ranch, survey corrections were completed and improperly placed markers disappeared. Updated boundary confirmations were filed. Access corridors remained available for lawful purposes exactly as they always had been. Nothing more. Nothing less. The property itself did not gain new rights. It simply retained the rights it already possessed. Sometimes that is enough. One outcome mattered to me more than anything else. The residents who had nothing to do with the dispute were protected from special assessments connected to the failed assumptions that triggered the entire mess. Several corrective measures specifically prevented ordinary homeowners from carrying the financial burden for decisions they never made. The school bus still used the roads. Delivery drivers still made their routes. Families still lived their lives. That was important. They were never the target. Several months later, every homeowner in the community received a formal correction notice summarizing updated project conditions, regulatory findings, and revised infrastructure assumptions. I kept a copy, not because I enjoyed being right, because it represented something simple. The record had finally caught up with reality. On a cool autumn evening, I walked down to the shoreline carrying that notice folded inside my jacket pocket. The lake reflected the orange glow of the setting sun while a light breeze moved across the water. Near the northern boundary stood a newly installed county-approved marker identifying the recorded easement corridor exactly as it existed in official records. Clear, accurate, unambiguous. I stopped there for a while. Then I looked across the water and thought about everything that had happened. The truth is, stories like this are not really about winning. They are about understanding what protects people when emotions, money, and pressure start pushing in different directions. A deed may look boring. A survey may seem forgettable. A recorded easement may sound like the driest thing on earth. Until the day those documents become the difference between fact and assumption. If there is one lesson I carried away from all of it, it is this. Loud voices can shape a conversation for a while, but records shape the outcome. This story is a dramatized reminder of something many people already know but sometimes forget. Protect your documents. Understand your rights. Verify before you assume. And when conflict comes, let evidence do the heavy lifting. The lake was quiet again by then, exactly the way it should have been.